So welcome everyone to this event, to this book launch even, the book of Law and Policy of New Eurasian Regionalization, edited by Anna Aseva, who I can see just there, and Zhenjie Gorski, whom is difficult. I've got a whole gallery here. So it's looking at economic integration, trade and investment in a post-Soviet and greater Eurasian space, published by Neof International Publishers. Okay, so that's the book. I've read some of the chapters, and I must say it's a very capital, sustained piece of research. And so this morning we have 7 speakers, and they'll all speak in succession. And according to the reglement, 8 to 9 minutes per person. And then I'll just have a few comments at the end, and then we'll open up for discussion. So can I please urge people to, as you go along, please make a note of questions, because it's very easy to forget them by the time we get to the end. So we can hopefully have a lively discussion, and the speakers can be then questioned, and their comments can be examined in some more detail. Okay, so that's the situation, and that's the order of the day. And so therefore, let's start immediately then. And the first speaker is Anna Aseva, one of the editors, who is, well, yes, so her topic is Wither Eurasian Regionalization, an introduction, and she'll say a few words more about the book. So Anna, over to you.
Thank you so much, Professor Sakwa, or Richard, if I may.
Richard is fine.
Okay, thank you. Yes, Anglo-Saxon approach.
Well, we have all become Americanized, I'm afraid. So
Eurasian approach doesn't allow
Okay.
us, but Anglo-Saxon approach does. And thank you very much, Alexander, and all other organizers who are behind this important and very first launch of our book, hopefully not the last one. So I am, okay, so with I'm done with the thank you part, because I have only 8 to 9 minutes. I will try to be brief. With the Eurasian regionalization, so when we started our introduction with Zhenjie Gorski, my co-author, co-editor of this book, who is unfortunately not with us today, but he's with us mentally. So we started with the very first phrase of our introduction that we borrowed from Ari Kakowicz, who said that, yes, in the very early 1990s, when some other scholars predicted the end of the history, right? So the 3 forces that shape the global political economy today are globalization, regionalization, and nationalism. So far in 2021, nothing has changed, I think. And when we submitted our introductory chapter with the Eurasian regionalization, with, I mean, the whole book, obviously, to the proofs and then to the print, some other crucial events driven by both globalization and nationalism took place in the region. I mean, obviously, the summer 2020 events in Belarus. I, of course, mean crisis, the conflict between Azerbaijan and Armenia over Nagorno-Karabakh, and many, many other crucial events, geopolitical, geoeconomic, institutional, legal, military events that happened all over the world, but especially in the region, in the course of summer and fall 2020, also the winter 2021, that affect directly the regionalization in the Eurasian region. They affect trade, they affect investment, transport routes, and the whole economic integration in the post-Soviet and greater Eurasian space. Obviously, they affect all these developments indirectly, but yet crucially, right? So unfortunately, these events, as the events in Belarus and the conflict between Azerbaijan and Armenia, et cetera, are not in the book for a very simple reason, because as you all know, we are all scholars, you all published, I read publications of most of people who are present Today, you know that publication of a book is a very long and very burdensome process. So between we submitted the book for proofs and then to print, and all these events happened, there was a margin, the time lapsed. So those events, which are crucial for the Eurasian regionalization, are not in the book, which only gives us an opportunity to write a sequel and maybe a trequel of the book, right? So this is what not in the book. So what is in the book? I have like 5 more minutes, I guess. So our book has shown that since the early 1990s, and especially today in recent years, the rules, norms, customs of cross-border trade, investment, dispute settlement in the Eurasian space underwent a significant transformation, right? So this regionalization is new. So this transformation resulted from the shift in trade routes across post-Soviet jurisdictions. Most of those post-Soviet jurisdictions still rely on natural resources, trade and transit. That's a kind of a curse. That's a benefit. That's a kind of a curse as well. And many different chapters, many different contributors looked at direct and indirect consequences of these sort of a curse. And both such trade and transit are also so far largely controlled by state-owned enterprises, sometimes operating in joint ventures with Western investors, sometimes not. Also, there is a shift that could be seen in dozens of rail connections, bringing East Asia with Western Europe alongside the Silk Road. Then there is also a number of cargo trains passing through China, Kazakhstan, Russia, Belarus, and it increases every year, right? And actually for the first time in history, that's somehow overlooked by many global and globalization scholars, but for the first time in history, the sea trade is overpassed by these, the number of cargo trains and the trade through cargo trains, right? And this trade in cargo trains is happening in Eurasia, right? As I said, through China, Kazakhstan, Russia, Belarus, etc. Last but definitely not least, and actually not even the last, the road transport sees similar prospects. So China joined the TIR, Transit International Routier Convention, which is the Convention on International Transit, Road Transit in 2018. And as maybe some of you or all of you know, the most recent development, or one of the most recent developments, is that today, in 2021, Turkey is connected to China by the road transport, bypassing Russia. Russia is not very happy with that, although that happens, and that's another development which is not covered in our book, and that we can cover in the sequel of the book, right? So all these developments, obviously, they call for what? The shifting trade routes. With them come possible conflicts over transit and other potential disputes, hence the specific question of the choice of law and the choice of forum, whether we can go to the Court of Eurasian Economic Union or alternative dispute settlement resolution options, such as international commercial arbitration, international investment arbitration, which we choose for the sales, transport, service contracts, etc., right? And there are also other crucial changes regarding the reintegration in the region. This is a particular objective, which is a different one. So the objective, the initial one of the reintegration, was to remove tariff and non-tariff barriers. So when you remove tariffs, when you remove tariff and trade barriers, it's called free trade area. When you remove non-tariff barriers, it's called customs union. When you add to the customs union a permanent court that decides different disputes between states, but also between individuals living in that states, that's called Eurasian Economic Union. So I stop here, and I think I pass the floor to my brilliant colleagues who both work as lawyers in the Court of Eurasian Economic Union, who both also brilliant scholars and who submitted chapters to our book, Kirill Antin and Ekaterina Dichenko. So I stop here. Thank you.
Thank you very much, Anna, and thank you very much for your excellent timekeeping. Can I just add that if people do have questions and comments as we go along, do please add them to the chat. I think that will be useful so that we can, if people have thoughts, are immediately prompted by a presenter. So as Anna said, we will follow the list as I think published. So indeed, next is Kirill to speak. So Kirill N10, please.
Thank you very much. It's a pleasure to take part in this official book launch, and of course it was a great pleasure to see the book published in a paperback and not only in an online form. I think that I should also probably give a short shout out to not only to the brilliant editors that we had the pleasure of working with, but also to the Transnational Dispute Management Journal, which published the articles. And because our chapters were first prepared as articles for this journal, we thought that we'd like to make them as concise and as practical as possible. Basically, the main idea behind the chapter, the Court of the Eurasian Economic Union, not just for government-to-government dispute settlement, was to sort of dispel this huge misconception. Because when you read the statute of the court, you have the first impression that the court is somehow extremely limited in its competence. It is prohibited from doing this. It is prohibited from doing that. It cannot award damages and so on. It cannot change legal norms. It does not basically have the power of annulment of the Commission's decisions. And basically, reading this big list of restrictions, you end up being completely depressed. You end up, of course, comparing the Court of the Eurasian Economic Union with the Court of Justice of the European Union, and well, this comparison, of course, will be harsh. And basically, it is true that while the competence of the Court of the Eurasian Economic Union is somewhat limited, and the absence of the preliminary ruling procedure is still a huge handicap that we hope to overcome in the future, but and overcome will need to pass through the reform of the treaty. So it is a middle and long-term perspective. But in basically what can be done immediately and what has been done by the Court of the Eurasian Economic Union during these first 5 years is basically to take the maximum advantage of the existing instruments. And we saw, for instance, that the court tried to be as welcoming to individual applications as possible. The court adopted a very liberal reading of the basic admissibility criteria of actions by economic entities. When we compare, for instance, the reading by the Court of the Eurasian Economic Union of the criterion of direct concern, we see that it is extremely easy for an undertaking, extremely easy for a legal person to challenge a decision of the Eurasian Economic Commission. The other advantage, of course, is that in the Court of the Eurasian Economic Union, there is no time limit for such a challenge, which basically allows economic entities to defend, to protect their rights and economic interests. So one of the things done by the court was this very liberal reading of the admissibility criteria, a very liberal reading of what a failure to act is, because it is possible for economic entities not only to challenge decisions by the Eurasian Economic Commission, but also to challenge the action or inaction of the Commission as well, failure to act by the Commission. A similar action, a similar type of action exists in the Court of Justice of the European Union, but there it is practically not used. It is there is a broad consensus in the academic community that this is a very ineffective kind of action. It is very hard to win. In the Court of the Eurasian Economic Union, it is an effective mechanism, and basically we had successful examples where economic entities were able to ask the Commission to conduct monitoring of what member states are doing in a certain area. And if the Eurasian Economic Commission conducts such monitoring and sees that member states are not respecting their obligations, the Commission may issue a reminder, very strong reminder for the member states. So this is a type of action which I think is quite effective, and economic entities were successful in forcing the Eurasian Economic Commission to conduct such monitoring of the application of the Eurasian Economic Union law. The second thing that the Eurasian Court has been doing for these 5 years was to use another mechanism called advisory opinion. And when you hear advisory opinion, you think, well, advisory, it means that no one practically has to listen to this opinion, that this opinion is just a recommendation. But the thing is that when the Court of the Eurasian Economic Union does interpret the law, this interpretation of the law becomes basically binding for everyone. It becomes binding for the Eurasian Commission, it becomes binding for member states. And we saw very surprising examples where practically immediately after the Court of the Eurasian Economic Union rendered advisory opinions, member states undertook proactive action to comply with such opinions. For instance, there was a dispute between Kyrgyzstan and Kazakhstan regarding railroad tariffs. And basically, we saw that Kyrgyzstan opted for this soft mechanism. Kyrgyzstan requested an advisory opinion from the Court of the Eurasian Economic Union. And 1 month after this advisory opinion, Kazakhstan issued a statement that it now does comply with such an opinion. It basically managed to solve the problem. And the Court of the Eurasian Economic Union uses this mechanism not only to reply to the question that the Commission or member states put before the court, but the court itself tries to use this mechanism proactively. It seizes the opportunity to establish, for instance, the main principles and main properties of the Eurasian Economic Union law. It used its opinion on professional sportsmen to establish the principle of primacy of the Eurasian Economic Union law over national legislation. It used the same advisory opinion to establish the criteria of direct effect, something that the European Court of Justice did in the famous Van Genten Loss ruling. So this is a very exciting opportunity because the court is basically only starting to formulate these main principles of the Eurasian Economic Union law. It is a historical opportunity, and the court clearly sees its task as basically being proactive, as not only replying to specific questions, but also formulating general principles. And something that is not in the book, of course, because of the time limit, is basically a declaration that happened in an advisory opinion rendered just recently by the court in 2021, where the court for the first time used the phrase general principles of the Eurasian Economic Union law to qualify the principle of proportionality. So the Court of Eurasian Economic Union does not only apply the sources of law which are enumerated in Article 6 of the Treaty on the Eurasian Economic Union, but it also basically created a new source of law by establishing these general principles of economic union law. And among these general principles is not only the principle of proportionality, but principles like non bis in idem, that the same person cannot be punished twice for the same offense. Or
1 minute, please,
Kirill. Or even the principle of protection of fundamental rights. In an advisory opinion on pensions, the court proclaimed that the level of protection of human rights on the level of the Eurasian Economic Union should not be lower than the level used by its member states. And this is a huge revolution because two of the member states of the Eurasian Economic Union are members of the Council of Europe. So they use the standard imposed by the European Convention on Human Rights, by the European Court of Human Rights. And as such, this standard also became the standard, compulsory standard for the Court of the Eurasian Economic Union. This standard or even higher. So to conclude, I would like to say that, we tried to make a short and concise article, but we think that it will be interesting for both scholars, academics, even people who never studied law, but it will give them an understanding of what the Eurasian Economic Union is and what are the opportunities to defend the legal interests of economic entities before the court. Thank you very much.
Thank you very much indeed. I found that a fascinating overview of the work of, I almost said the ECJ, but the counterpart. That's fantastic. We'll come back to that. There's a lot of, I think, issues and questions you've raised there. But we'll move on now to Yekaterina Dyatchenko, your co-author. But so Yekaterina, where are you?
Yes, I'm here.
Right, okay. Hello. Over to you.
So thank you for this opportunity. The chapter Eurasian Economic Union Competition Law, What's in a Name, gives an analysis of the provisions of the EAU Treaty relating to competition law, general principles of competition designed to harmonize the legislation of member states, and general rules of competition containing prohibitions addressed to economic entities. A particular emphasis is put on the coordination of economic activity, which is a separate offense under the EAU Treaty and could be applied both to associations of undertakings or the so-called facilitators, entities that are not active themselves on the market, but who play a role in the establishment of implementation of a prohibited agreement. Our article also discusses the division of competence between the Eurasian Economic Commission and national competition authorities, as well as judicial control exercised by the court. We thought that this field of law might be particularly interesting for several reasons. First of all, because of its practical significance. The Eurasian Commission does possess extensive powers in the field, allowing it to conduct investigations and impose fines on undertakings. It is true that in the first couple of years, the Commission was predominantly busy with establishing the necessary legal framework and didn't have the resources or maybe expertise necessary to conduct many investigations. But now we see that the situation is changing rapidly. And this means that economic entities, including, that is important, foreign entities operating in the EA-EU, need to be aware of the regulation in this area. Secondly, the role of the judiciary is equally important. Not only does the EA-EU court have the power to control the legality of Commission's decisions, but it managed, through its advisory opinion, to establish some of fundamental principles and rules in this area relating to the divisions of competence between the Commission and national competition authorities, or the margin of discretion of the national legislature. One particular example is the advisory opinion of the application of the non-bis in idem principles that Kirill told about a few minutes ago. In this advisory opinion, the court ruled that this principle precludes a situation where the same economic entity is prosecuted for the same conduct by the Eurasian Commission on the basis of the EA-EU Treaty and the National Competition Authority on the basis of national legislation. Another one is the advisory opinion on vertical restraints, where the court established that general rules of competition have direct effect and should be directly applicable, thus allowing the application by national competition authorities and national courts. Thirdly, EA-EU law is predominantly based on Russian competition law, which in its turn was heavily inspired by EU law. And this situation allows us to draw many interesting parallels between different competition law provisions. For instance, unlike EU competition law, the EA-EU Treaty only prohibits dividing the market according to the territorial principle for horizontal agreements, but not for vertical ones, whereas in EU law, the imposition of absolute territorial restriction is considered to be hardcore restriction. The case law of the Court of Justice of European Union can also serve for us a source of inspiration, like with the non-bis in idem case. But interestingly enough, that EA-EU court opted for a slightly different approach to this principle, which is reminiscent of the conclusion of the European Court of Justice's Advocate Generals, and more in line with the approach of the European Court of Human Rights. Finally, I would say that our chapter is pretty much like everything you wanted to know about the EA-EU competition law, but were afraid to ask. And I'm sure that it will be interesting both for legal practitioners and for scholars. Thank you for your attention.
Thank you very much indeed, and well within the time. Thank you. As you say, it's a chapter which is quite exhaustive in its detail, and it's got everything there, which I think is doing a capital contribution to the literature. So great, thanks. So we now move on. We now move on to Glenn Deason, who will be talking about the geoeconomics of the region. So over to you, Glenn.
Thank you. So, yeah, so I will focus less on the technical details, instead, assess it more through the prism of a geoeconomic theory. So obviously I conceptualized the Eurasian Economic Union as a geoeconomic bloc and analyze its strengths and weaknesses accordingly, as well as the opportunities and risks it faces. So geoeconomics simply builds on a realist understanding of political economy. So it's about the symmetry of economic interdependence. As in an economically interdependent partnership, you will have each side gaining some influence over the others, and thus each side also loses some of their autonomy. Now, geoeconomics is then largely about skewing the symmetry of interdependence. In other words, you would like to be less dependent on others, and others should be more dependent on you, thereby creating some asymmetrical interdependence that results in favorable trade agreements and also political power. So, well, case in point with China and Kazakhstan, yes, they're interdependent, but obviously you have one party where the balance of dependence shifts in the favor of China, which then allows it to dictate the trade agreements, but also extract certain political capital from this partnership. So it's within this format that you have systemic incentives emerging for the creation of geoeconomic regions, like the Eurasian Economic Union, which are a natural instrument of geoeconomic power as a group of states use collective strength to negotiate favorable terms or symmetry with another actor. So not unlike a military bloc where state A and B cooperate for leverage against country C. However, unlike military blocs, it doesn't have the same zero-sum function. Indeed, we often see that a geoeconomic bloc can create more durable relations. For example, Russia, Kazakhstan, Belarus, they might all be more inclined towards deeper economic connectivity with countries such as China if they can cooperate collectively under the Eurasian Economic Union, as they then have less to fear in terms of preserving political sovereignty. So we see, like I heard a lot of comparisons with the EU. So the EU obviously also a geoeconomic bloc, which enables the Europeans to improve their symmetry in relations with the United States, but it also allows them to assert collective hegemony, if you want, in the pan-European space. And the Eurasian Economic Union similarly enabled these former Soviet republics to cooperate with China and also ideally the West from a more equal footing. So this kind of maps out the strengths and the weaknesses of the Eurasian Economic Union, which can be assessed both from its internal as well as external strength. So the internal cohesion of geoeconomic blocks is quite important in order to act as a unitary actor, in order to mobilize the resources towards collective ends. And there will always be the systemic pressures towards moving towards an internal balance of dependence. So you find this within a region and a bloc. So for example, in transatlantic partnership, we see that the United States was way too dominant, which has created an incentive for the EU to collectively come together to have more symmetry in relations. However, you also see this dynamic within blocs. So for example, in the EU, you have increasing power concentrating in Germany. And again, this concept of a German-dominated Europe, it's obviously not popular in Poland, also Greece. And we all see that was part of this Brexit rhetoric, that this is not the Europe the British were going for. And you see the same in the greater Eurasian region, where the geoeconomic power of China and the EU incentivizes the development of the Eurasian Economic Union for more favorable symmetry. However, a challenge for the Eurasian Economic Union is the lack of balance of dependence within this bloc, as Russian power is rather overwhelming. And the dilemma therefore for countries such as Kazakhstan and Belarus would be to need to see the benefits of the Eurasian Economic Union in their external partnerships to justify the lack of a balance of power within the bloc that enables this strong Russian influence. And this also incentivizes Russia to make the bloc more outward-looking. So essentially delivering on these preferential trade agreements with external partners, as opposed to attempting to monopolize on influence, if you want. So, but this is also why it would be better to have other large economies within. So countries in Ukraine or even Iran, as again, Russia would still be the first among equals, but power would then be more dispersed and make it more easy for countries such as Kazakhstan or Belarus. So again, this is important for consideration for issues such as development of common currency, because obviously the common currency would make the Eurasian Economic Union more efficient and have more economic competencies. However, one also have to recognize it's a very federalist project. If you have a monetary union, you need a financial union. If you're going to have a financial union, you really need a political union. And this obviously aligns with, it's not a problem for a country like Russia, which would be the main one, but it represents a challenge for countries, again, like Kazakhstan or Belarus, and they would have to see the external utility of such measures in order to justify the concentration of power within the bloc. So also when it comes to the external strength, I talked briefly about it, but obviously the purpose is to create a more favorable balance of dependence with external powers. But it also is a need to encourage external powers to actually work with the Eurasian Economic Union. Because again, why would any external powers want to work with it? there has to be some value and benefits to external powers. Again, we often see the European Union complains that China and Russia undermines its unity by engaging with member states. And again, my answer is always, well, why wouldn't they? Why would you deal with 27 member states standing collectively using their collective strength? It doesn't really make any sense. And again, the US has some interest as, yes, power within, by accepting the EU, power within the West is more dispersed. However, you then have the collective strength to advance this unipolar moment. Now, this also have to be then applied to the logic of the Eurasian Economic Union. One of the ways is obviously to have these interregional formats. For example, if the EU and the Eurasian Economic Union can establish some cooperative format, but given that this has been rejected by Brussels, from my perspective, there wouldn't be much reason for Russia, for example, to want to work with the EU unless this is some reciprocity. And that's probably why it would lean more towards employing some wedge tactics, much like the Europeans are doing within the Eurasian Economic Union. However, the Eurasian Economic Union, it does offer practical benefits for China. Again, we see some practical issues such as offering one tariff zone between the EU and Chinese borders, but also it's not just the benefits that the Russians can bring to the table, it's also the pain. That is, Russia can make life very uncomfortable for China in Central Asia, for example, if it does not accommodate Russian interests as well and try to harmonize competing integration formats, which is why you see these interregional solutions, being the Eurasian Economic Union cooperating with the Belt and Road Initiative under the SCO. And again, this should be also the format for the Eurasian Economic Union and the EU, similarly resolving border issues in the shared neighborhood, but also resolving other issues between the Europeans and the Russians, which were never solved after the Cold War. And again, that's just how I would see the Eurasian Economic Union. So again, far from being any hegemonic project similar to anything we saw in the 19th century, rather I would see it as an important component of a larger, greater Eurasian space where former Soviet Republic can seek this collective bargaining power in a more multipolar Eurasian framework. So engaging both with the Europeans and the Chinese. Obviously, more success so far to this date with the Chinese as opposed to the Europeans. So yes, I'll leave it there, and hopefully I didn't go over time.
No, you were actually spot on. Thank you very much, Glenn. That's great. So no, we're running very much to schedule, even in fact a couple of minutes in the bank because of the previous one. Okay, so let's move on. As I said, if you have any comments or questions, please do put it in the chat. So we'll look at that when we come to the Q&A session after all the presentations. But now we'll move on to Anastasia Likhachova, who will be talking about International Strategy Toolkit of the EU. So over to you, Anastasia, and welcome.
Dear Richard, dear colleagues, thank you very much. It's a great pleasure to be a participant of such an event. It was a great honor to join the book. As far as me and my co-author, Alexander Korolov, who will present next, we are not lawyers. We are focused on international relations and international research. This was our focus on Eurasian Economic Union, and particularly we made a stress on the role of Eurasian Economic Commission in international opportunities that member states get due to their participation in Eurasian integration. The major focus that is usually a bit lost, particularly in Russian discourse when we speak about Eurasian integration, is that Eurasian Commission is the major body that is responsible for all trade negotiations with foreign partners. And keeping in mind that since 2012, 2011, depends on the starting point of the analysis, but still, that was the moment that we can call the launch of the pivot to the East policy of Russia. And if we analyze any pivot to the East, pivot to Asia, pivot to China policy of any state of the recent 20, 30 years, it was a story of trade negotiations, besides all issues. And the fact that it wasn't Russian authorities directly, but Eurasian Economic Commission established and well, they started to be in place since 2015. So in 3 years, 3 or 4 years after the launch of this pivot to the East policy, it was a very interesting issue to which extent Eurasian Economic Union serves to the promotion of this interest. If we look through the track record of Eurasian Economic Union, by now we can see that it definitely started to act in this direction. And the first FTA was signed with Vietnam. So it was East, it was pivot. And from this point of view, it was very effective. Particularly because Vietnam was a very good partner for these negotiations. On one hand, it wasn't too small to agree with anything that the Eurasian Economic Union would like to promote.
I think there is a glitch.
Yes. Anastasia, has the screen frozen for everyone else? So Anastasia, you seem to have frozen. Maybe go in and out again. Take your time. I assume that's what's going on. So we'll wait for Anastasia to get back in.
So far, there are no questions in the chat.
Yeah. It shows just how good the presenters are, that they've covered all the angles.
So crystal clear to everyone. Yeah. Everyone like read the book and everything is clear. I think
yes.
that's
but don't get too don't relax too much, because I've got some points. So stay on your toes.
That's really good. That's great. I saw that you have been taking a lot of notes when I was speaking.
I'm a compulsive note taker. Yes.
Yeah. Okay, Anastasia.
Anastasia, you're back. Welcome. Yeah. Welcome. We'll add the time lost here, so don't hurry. Take your time. So welcome.
I'll try to speak 125% plus quicker. So when we analyzed and when we talked with Eurasian Economic Union officials, the very important moment that is usually undercovered, and we try to show it in our chapter, was that for Eurasian bureaucracy, that was the very first lesson and the very first lessons on how to build this consensus among firstly 3 then 5 member states to set not just the demanding position on negotiations that is not so hard. We want to that you open everything, and we want to open everything, but to some defending position. And Vietnamese were very good experts in this slow promotion of these defending positions. From this point of view, first FTA experience was very productive, and we could say that this educational curve on how to build the consensus with mid-sized partners was done. We later we saw the experience of negotiations with Iran. That was much more difficult partner, but still it wasn't the, I would say, the first league of trade negotiators. The interesting piece here is trade negotiations with Singapore. As far as Singapore has almost 0 tariffs for everything, so it wasn't too hard to build a consensus on trade. But what Eurasian Commission did, they really worked as an operator of 5 different positions of member states on services, because service negotiations are out of mandate of Eurasian Economic Commission, and there was not an opportunity to set one consensus set of demands, but they worked well. And with Singapore, the FTA signed with Singapore opened like a new chapter in capacities of Eurasian Commission in terms of parallel negotiations on trade and on management of negotiations among 5 member states with other partner on services. But the problem is that the other negotiations that were launched with Israel, with Egypt, with India, they also fit to this similar logic, not to deal with extremely big partner that would immediately overwhelm you on the negotiations, but here we see more limitations related to bureaucratic capacities of the Commission, because the same number of people who worked on firstly 1 Vietnamese negotiations, then 2 or 3 parallel negotiations, now have to work on more than 7 tracks. And there was no any extension of departments and sub-departments that are responsible for trade negotiations, keeping in mind that Commission has a very important track record related to relations with China. There was a non-preferential trade agreement signed with China in 2 years ago, but of course it wasn't it didn't have any profound economic effect, and it was mostly political agreement. But still, the conjunction framework between Belt and Road Initiative and Eurasian Economic Union is still an international agenda of the Commission, because officially, for example, Russia didn't react to Belt and Road Initiative. It was Russia didn't declare itself as a country of Belt and Road. Well, that is pretty obvious that it contradicts to the whole political tradition of the country, but it was a very interesting format on how to react, and it was conjunction of Eurasian Economic Union and Belt and Road. Still, we see a profound political dialogue here, but as for economic fulfillment of this framework, well, I would say that the result is pretty moderate by now, especially if we keep in mind the coming crisis. Probably there should be some reconsideration of this conjunction framework in coming months or years. Maybe it will be some digital belts and roads, maybe it will be some other reshaping of the project, but it's clear that by now Eurasian Economic Union didn't get real capacities to take Russian-Chinese agenda under its mandate. That was the set of examples and the evolution of this negotiation educational curve of the Commission that we covered in the book. And also I would like to say a couple of words about the problems we also tried to stress the attention on. Commission mostly focuses on FTAs, and it's good because 5 years ago there was no any FTAs in the agenda at all, except in the Commonwealth of Independent States. That wasn't a real FTA by its essence, but now we have about 5 to 7, and it's good achievement. The problem is that Commission has no any idea on how to promote FTA plus formats, the issue where, for example, European Union is extremely strong partner. If we speak about countries that are located 1,000 kilometers away from borders of Eurasian Economic Union, maybe that's not a problem. If we speak about countries that has a long history of very dense communications and relations with countries of Eurasian Economic Union, by now they face a very radical dilemma. Either they can follow the same rules mostly that Vietnam follows, or any Vietnam, Egypt, Singapore, or they have to become a member. That is a very tough dilemma that faces lots of domestic debates in Uzbekistan, in Tajikistan, in other countries, in Mongolia, that wasn't, of course, a USSR member, but has a pretty dense relations with countries of Eurasian Economic Union. Our very profound hypothesis, suggestion, beliefs is that to become more efficient on this track, especially now when countries focus mostly on their domestic agendas, I mean countries worldwide, the idea that they have to, that the Eurasian Economic Union puts its partners in face of very tough dilemma is not the best strategy. And in coming years, Eurasian Economic Union and particular Eurasian Economic Commission that is responsible for this track have to elaborate very clear frameworks, which FTA plus solutions they could suggest to their possible partners. Maybe traditional FTA with very advanced appendix on migration, on free move of people, on I wouldn't like to focus on Eurasian Schengen, but we have no visas, but some extensions for students, some extensions for services, for exchange for service markets. Otherwise, it will be very clear that that integration would either focus on itself. That maybe is not the best, it's not maybe the worst idea, but from international point of view, it won't be so effective, of course. Or it will become more and more political, more and more politicized, more and more challenged domestically among potential partners. That probably wouldn't really make the process of integration easier. It's already very tough because we already have tons of regulations elaborated by 5 countries, and any country that would like to join will have to go through a very intense re-regulation, re-liberalization, or in contrast, liberalization of its markets. So it's very difficult bureaucratic process by now for any country that likes to join. And if we multiply it by domestical challenges and claims of opposition that it's not maybe the best idea, we suggest that FTA plus formats similar to European experience could be a very good idea for coming years. I would stop here, and Alexander, I hope, would develop some points and suggest his own.
Thank you very much. Can I just say that on that point, for a technical one, is there an equivalent Russian term for the acquis communautaire? You just mentioned the body of EU law. Obviously, do we use the French term, or is there a special term for the EU?
No, basically the EU acquis has already been used in the legal literature by professors Kalnichenko and Petrov for the first time, I believe, and we started to see this term being used more and more.
That makes sense. Yeah. So we don't want a proliferation of terms. So good. So the EU acquis. Good. Excellent. Thank you very much. Okay. Thanks indeed. So sorry, Alexander, over to you. So part 2 of that. So over to you. Thanks.
All right. So thank you. First of all, I would like to thank all of the colleagues for the invitation to this presentation. I'm very proud that I have a chance to present my thoughts on the Eurasian Economic Union, on the Eurasian economic integration itself. So yeah, basically my presentation will be based on what Anastasia mentioned, because we have the same chapter, and just I will follow up her in many respects. So we can say that during the first 5-year span, the Eurasian Economic Union and the Eurasian economic integration itself was quite active in terms of the developing of foreign trade partners, Vietnam, Singapore, preliminary agreement with Iran, the non-preferential trade agreement with China. So it's actually very active, and actually a very proactive approach of the Eurasian Economic Union towards the globe, and especially towards the different regions like Eurasia or Southeast Asia, or even different regions like Israel, as Anastasia mentioned, and European countries like Serbia. But one of the advantages, and actually one of the starting capital or starting resource for the Eurasian Economic Union is actually the youth, right? Because the Eurasian Economic Union is a very young organization. It's just 5 or let's say 6 years this year. So it's actually almost every agreement, no matter how powerful that is, no matter what kind of format is that, almost every agreement was supposed to be the major advantage and the major success story of the Eurasian Economic Union. And of course, I do agree with Anastasia when we were talking about Vietnamese, the agreement with Vietnam. So in terms of the idea, right, in terms of the format, of course, we can say that this one is the successful story of Eurasian Economic Union. But if we dive deep into more details and into the very agreement, right, and very substance of this one, we can say that it's not that easy, right? because we can say that since the 2016 when this agreement was ratified, the trade volume between Eurasian Economic Union and Vietnam did not skyrocket as maybe somebody anticipated that. And currently it's just $6.2 billion US, which is very miserable. Of course, especially if we compare these sets of agreements with different other countries and partners like China or Japan or South Korea or even India, right? So $6 billion is almost nothing, right? So we can say that the trade volume between Eurasian Economic Union and Vietnam currently is non-existent story, right? And especially the problem is that the 72% of the trade volume between Vietnam and Eurasian Economic Union currently is the imports from Vietnam towards the Eurasian Economic Union, right? So this is a structural problem for Eurasian Economic Union, and it will be actually in the foreseeable future. The other actually challenge is, of course, these we can call it so-called the integration race. So what I mean by the integration race, so the majority of developing and developed countries, and not just countries, but the associations, regional trade blocs, they actually switch their foreign policy strategies from the classical free trade agreements to the more updated version, more advanced version, which is FTA plus. Vietnam, South Korea, Japan, China, European Union, ASEAN, Mercosur, all actually did this path, and actually all these regional trade blocs did this story and did this very successfully, right? So that's why it's of course one of the major, very important prerequisite and one of the major goals for Eurasian Economic Union to switch its foreign policy strategy, foreign economic strategy from the classical free trade agreements to the most advanced, and actually which is currently is called the classical free trade agreement plus, which is not only about the trade, which is not only about the trade barriers, but also about the services, also about the investments, also about the intellectual rights, property, and stuff like that. The other very important topic for the Eurasian Economic Union, and at the same time, one of the major challenge for the Eurasian Economic Union and the Eurasian economic integration itself is actually the signature of Regional Comprehensive Economic Partnership, the RCEP, which emerged as the new substance in November last year, 2020. So why is actual RCEP is very important, even though neither Russia nor Eurasian Economic Union is represented in the RCEP. So actually, this is the problem why the Eurasian Economic Union is not represented in RCEP, and this is actually the problem, the structural limitation for the Eurasian economic integration in foreseeable future. Why is that? Firstly, it is about the RCEP is the largest free trade zone once it ratified. So nowadays it's not ratified, it's just signed by 15 member states. So once it ratified, this will become the major free trade agreement zone. Secondly, this RCEP agreement is about the substance, right? This is about the new trade rules, the new procedures, the new free trade regimes of how to handle the noodle bowl effect, for example. And the third one, RCEP is actually being the major playground for the regional and global value chains, which are disrupted currently because of the pandemic. But of course, it will strike back and bounce back after the pandemic is over. So, this RCEP is actually the second trading partner, totally RCEP member states, the 15 RCEP member states are the second major trading partner for the Eurasian Economic Union. And it's more the share of RCEP in total Eurasian Economic Union foreign trade volume is 30%. Just European Union is more than 30%, right? So RCEP is the second one. And as I previously mentioned, Eurasian Economic Union is isolated from this process. And in foreseeable future, it's impossible for Eurasian Economic Union to squeeze in this integration race, to squeeze in RCEP agreement because of different reasons. And the first reason, there is no free trade agreement with ASEAN. So the free trade agreement with ASEAN is actually the, let's say, the first step, the first phase control towards the becoming the member state of RCEP. So and it's a possible enforceable future. The negotiation free trade agreement with ASEAN between Eurasian Economic Union and ASEAN is the question of 5-10 years maybe, but not of course in the 2 or 3 years in future. So the logical question arises, right? So how to unlock this Eurasian Economic Union potential, because of course Eurasian Economic Union does have economic potential and does have foreign policy and foreign economic instruments how to handle these issues. So, but the first two, and of course one would argue that Eurasian Economic Union should push itself into more harsh negotiation schemes with, for example, Japan or South Korea or European Union or ASEAN or Mercosur. Of course, one could say that, but this is very long-term prospect, especially if we're talking about the integration formats, because Eurasian Economic Union does not have a lot of not just competences, right, but Eurasian Economic Union, because the competences of Eurasian Economic Union are limited currently. Right, it limited only with trade negotiations, but no negotiations on services and no negotiations on investments. So how to unlock this potential? First two things is actually Eurasian economy has to look down on itself and look first of all on itself, not on the foreign partners like Japan or European Union or ASEAN, but first of all look at itself, because there are many actually issues and many limitations inside the Eurasian Economic Union in terms of the foreign economic policy. And first of all is actually the limited export structure, because right now 54% of the export from Eurasian Economic Union to foreign partners is actual mineral resources, and 80% of all export is actually the intermediate goods. So this is actually the structural limitation, because when Eurasian Economic Union wants to attract its foreign partners like ASEAN or Mercosur or Pakistan or Iran, first of all, it has to actually offer something very attractive, like the other states do, or the other regional trade blocs do, like European Union or ASEAN, right? So this is actually one of the first, let's say, prerequisite for the development of Eurasian Economic Union foreign economic strategy, not just to sign free trade agreements with anybody who's actually wants to do that, but first of all, look at yourself and try to actually fix the limited export structure issue. The second one, as well as which correlates with the first one, is the enlarging of competences of the major agent of Eurasian Economic Union integration, which is Eurasian Economic Commission. Once again, currently the competences is only over the trade, which is actually not very good thing for Eurasian Economic Union strategically, because it actually artificially limits the possibility for Eurasian Economic Commission and Eurasian Economic Union itself to integrate more deeply into the regional and global value chains, which is the major trend of regionalization currently, and even during the pandemic is very actual and very topical. And the third strategic step, of course, is the shift from classical free trade agreements, which currently exist inside the Eurasian Economic Union, which were signed with Vietnam, Singapore, Serbia, and preliminary agreement with Iran, is the more advanced treaties, more advanced agreements in new formats with FTA+. First of all, we can say about the agreement with China. So we all know that currently Eurasian Economic Union only has the non-preferential trade agreement with China, right? Which is, once again, is not a free trade agreement. It's just a let's say almost the memorandum of understanding between the parties how to actually trade, how to actually integrate more deeply in the Eurasian landscape. So of course the question of China is very sensitive, especially for Eurasian Economic Union member states, and they're deadly afraid of any negotiations on free trade agreement with China, saying that if we actually eliminate all the tariff barriers, China will overflow the goods in the domestic market on Eurasian Economic Union, and it will devastate the Eurasian economic economies. So this is actually one of the topic which is very popular among the scholars and among actually the political elites of Eurasian Economic Union. But it's not actually true. It's not actually the case, because we can look at the ASEAN experience, how they use this agreement with China.
One more minute, Alexander.
Sure. I'm finalizing my speech. So what can be done is actually the preliminary free trade agreement with China, with different actually protectionist measures, with different transition periods, as ASEAN did with China, and it was very successful. And ASEAN became one of the major beneficiaries of this agreement. The second one can be, of course, we should not forget about the negotiations with European Union. Currently, it's impossible due to political tensions, of course, but it doesn't mean that we have to, the Eurasian Economic Union have to forget about European Union as another very strategic asset and very strategic direction of foreign economic policy. And finally, in the long term, of course, is integration with ASEAN, with Mercosur, with African Union, and with BIMSTEC and many other integration associations in different regional trade blocs. But first of all, this will be my final 2 words, that first of all, of course, it should be the elimination of institutional inertia, the enlargement of competences, and of course, the diversification of export structure, which is the first prerequisite towards the integration more deeply into regional global value chains. Thank you.
Thank you very much indeed. Yeah. And thank you for those who are putting questions into the chat. So may I encourage you to keep doing that. They seem to be focusing on Iran, but that'll be interesting. So do keep please adding to that. So now we come to our final speaker, Dmitry Davydenko, who'll be talking about transnational dispute settlement. So over to you, Dmitry.
Thank you very much, Professor Safan. So I think that I should be brief. My article covers a rather different aspect of issues relating to economic integration in the Eurasian Union. Mostly it's about private dispute resolution, especially between economic entities of many states, and not only economic entities from the countries of the Eurasian Union, but also from other countries. So it's about the International Commercial Arbitration Court by the Russian Chamber of Commerce and Industry, which is remarkable in many aspects, because first of all, it's the successor, legal successor of the Foreign Trade Arbitration Commission established by the Soviet Chamber of Commerce and Industry in 1932. So the MKAS, as we call it in Russian, International Commercial Arbitration Court, will celebrate 90 years next year. It's second oldest arbitral institution based in Moscow in Russia. Another one is the Maritime Arbitration Commission, specialized on disputes in the area relating to merchant shipping. So, unlike the Maritime Arbitration Commission, this is MKAS is the universal arbitral institution. Any private law disputes are resolved by the arbitral tribunals under its auspices. The experience is already large, and more than 10,000 cases have been resolved during the history. But what is remarkable is that it was created in the early Soviet history, when it became impossible to do without such an arbitral institution, which would not be a state court, because parties from many countries, not only from Soviet Union, but from the West, needed some neutral ground. And this neutral ground should not necessarily be some arbitration institution in London or elsewhere outside the region of the Soviet Union. So it was created as one more alternative for the parties to include in their commercial foreign trade contracts how to resolve disputes. The most important thing is that frequently the arbitral tribunals rendered awards against Soviet entities. So they always kept the principles of neutrality and professionalism. And that is why this institution gained great respect and recognition in just several years. And in many situations, the parties to foreign trade contracts involving at least one from the Soviet Union had their cases considered in this arbitral institution. What is remarkable in the case today is, for example, that there is a clear gender diversity there are numerous women between arbitrators on the list of recommended arbitrators of the UNCAS, and very frequently the chair of the arbitral tribunal is a woman. This is quite a normal situation in UNCAS, and I know that in many countries it is otherwise, that there is a problem of the diversity. About 1/3 of the listed arbitrators for international commercial disputes are non-Russians, are from other countries. Many arbitrators are law professors, sometimes practicing lawyers, or sometimes, as it happens in former Soviet Union, they are both law professors and practicing lawyers. This is a particular feature of our region, that if you are specialized in private law, you usually would rather combine your practice, legal practice, with academic work. What is also important is that currently there are also some disputes resolved under the auspices of this arbitral institution, where both parties are not from Russia, but from some other states, usually from the states of the Eurasian Economic Union, but not necessarily. For example, there are cases where one of the parties is from the United Arab Emirates, and another party is from Uzbekistan, or one party is from Tajikistan, another from Uzbekistan, and several other disputes, sometimes very large and important, several dozens, millions of dollars, are also resolved under the rules of the CAS. And the arbitrators are not necessarily Russian. They are from numerous countries of the world. The parties are free to choose the person they trust as their arbitrator if this person is neutral and qualified. CAS awards are very important because they are published in the databases on the same as Russian court judgments, and usually the arbitral awards are much more detailed than state court judges, because arbitrators usually have more time for consider the dispute and to write a detailed award than a court judgment. Also, frequently the arbitrators apply not necessarily legislation by some state, not necessarily international treaties, but some transnational set of rules. Sometimes uniquely only this set of rules, such as MIDRA principles of international commercial contracts. So nowadays, this is still a very important arbitral institution, although in Russia there are a few others which are also important, and now, of course, each of them tries to attract more disputes. So the trend today is to establish local branches in numerous regions of Russia, branches of arbitral institutions, to hear disputes, to be closer to parties from this particular region. This is briefly what I would say to introduce my article. Thank you.
Thank you. I turned off my sound because there was a whistling noise. I don't know where it came from, so I thought it was best to do it. Okay, great. So lovely. Thank you very much, Dimitri. So that's all our presentations for so far. So we'll now move into the Q&A. I notice that there are some questions. We'll come to those in a minute. I'll just make some comments. I'll start by being very specific, and then I'm going to make some general thoughts. So as for the specific comments, I'll start just for convenience for my paperwork at the end. So Dimitri, your paper. So it's really fascinating to see this institution, which born in the Soviet years, in a way that it's taken shape in recent times, and so you've given a good study of it. It's just I just wanted a simple question about access to this court. You know, you say it deals with quite a heavy caseload. I mean, it's quite a lot. Where was it? Towards the end, you've mentioned quite a large number of caseload. But I just wondered, you know, what sort of filtration mechanism there is to get access to the court. And obviously it deals with international issues, but it's, you know, what does it say, you know, larger thought about the rule of law in Russia, you know, given the context of Restraints and so on. So can you just maybe take it as we go along? So Dmitry, any comments on that?
Well, yeah, Professor Sako, if I understood correctly your question, there is no problem with access to the this arbitral institution from CAS because, well, it's enough that there will be a valid arbitration agreement. So the in the contract and the dispute is arbitrable. Then there is an arbitration fee, but yes, it is smaller than in most arbitral institutions known in the world, such as the Stockholm Chamber of Commerce, or of course the International Chamber of Commerce. The caseload is well, it is large, but it's small in comparison to state courts, because state courts consider millions of cases. About more than 1 million cases are considered by Russian state courts annually, and in CAS it's only about 300 cases, sometimes less, sometimes more. So I think that the facilities are quite sufficient to arrange a hearing, and the hearings are indeed conducted without waiting. I'm sorry, could you repeat your second question about rule of law?
It was fine. It was just a you know, a sort of a generalization question. What does this tell us about the larger issue of the rule of law and impartiality and so on? And obviously, as you know, it's certainly in the West, endless talk of the way that of Restraints, of attacks on commercial entities within the country, of course, but also some famous cases externally, the Calvi case and others. So it was just a brief comment on you know, on the status issue, if you like.
Well, I recall some cases in which Yukos Capital was a party claimant, and the Russian state entities were respondents, and the disputes were heard in CAS. This was several years ago, and they were resolved in favor of Yukos Capital. So there are the arbitrators were famous Russian lawyers. Well, I think that neutral, this is a good ground to hear international commercial disputes involving foreign entities from many countries. But of course, it cannot be ignored that the final say is frequently with the courts, the state courts, which have authority to set aside the arbitral awards if they found the violation of public policy. Of course, on the exceptional grounds, but still such grounds exist. Obviously, the arbitral awards may be challenged, not on the merits, of course, but on exceptional grounds in Russian state courts. However, interestingly, sometimes the awards rendered in CAS were set aside by Russian courts, but subsequently enforced in other countries because the courts of other countries did not agree with found that the procedure in the Russian state courts in the particular case was contrary to standards adopted by that jurisdiction. So the awards were enforced in other jurisdictions.
Thank you. So I'm going to, as I say, work my way up the list, as it were. So Alexander, you know, I really like or interesting idea about the the integration race, as it were, and Eurasian Economic Union is a late entrance to this race, and it's it's done so in almost in very adverse circumstances. With Second Cold War, with still the legacy of the global financial crisis, and now the pandemic, and so on. And I just wondered, clearly, given some earlier discussions, we have the shift to FTA plus, and that the EU is rather a latecomer. And I think Anastasia, of course, talked about this as well. And so my sort of thought there is that, in a sense, that the trend now, I mean, it's the integration race. Yes, the RECEP is huge in all sorts of ways, but what that shows, in a sense, is that the pressure now is to shorten value chains, and therefore, RECEP itself is a sort of not global regionalism, but to try to focus on your core, your heartland, if you like. So in that race, it seems the EU is losing out a little bit, because while you see, there's always a tension between national and integration, but nevertheless, I wonder whether this sort of, this pressure now to shorten the value chains, to reshore production and everything else. And in other words, the populist challenge, and when I go to Anna later about globalization and deglobalization, but in that context, I wanted just maybe a brief comment on that.
Yeah, sure. Thanks for your question. When I was talking about the integration race, so in the paper and later on in today's discussion, so I was firstly focusing on the so-called, not even the regional trade blocs like European Union or ASEAN and in others, but on the so-called mega regional trade initiatives like Regional Comprehensive Economic Partnership, RCP, and Trans-Pacific Partnership as well, where Eurasian Economic Union is not presented. So, so from my personal perspective, so this will be the major integration race in foreseeable future between the RCP and between the Trans-Pacific Partnership, and maybe Joseph Biden will join one day the Trans-Pacific Partnership. Great Britain actually already introduced its plan to integrate in Trans-Pacific Partnership. So maybe it will be another hot topic in terms of the integration race in 2 or 5 to 10 years. And Eurasian Economic Union, of course, has to adapt towards this new integration environment.
Yeah, that's really great. Yeah, and of course, TTIP, the Atlantic one, was abandoned.
Yeah,
and there's not much chance of that coming back to life. But no, that's really fascinating, the whole thing. Anastasia, is Anastasia with us?
I think she's not with us, but I can answer.
No, it was just there's a few things, but in that case, it was just to question this whole even notion of pivot to the east. I'm a bit quizzical and skeptical about that. Just this morning, I was looking at Putin's speech in November 2000, a big article in Nezavisima Gazeta saying how important the east is for Russia, and of course Yeltsin made opening up to it. In other words, pivot to the east is a term which was used, of course, by the, how can I put it politely, by Hillary Clinton about the United States. And even then it was a sort of part of a geopolitical shift. And, I just say be very cautious about using this term, because Russia has all, from the full engagement with APEC from 2000 onwards in the Putin years and so on. So Russia has never pivoted to the east. It's always been part of the east. So it was just, I mean, I have some other points, but maybe you want to deal with that one.
Yeah, so I can say, as maybe Anastasia tried to portray that's this like official strategy of Russia's foreign policy after 2000. Let's say not even after the Ukrainian crisis in 2014, but maybe since 2012, when the Ministry of the Development of Russia's Forest was launched, and the APEC summit in Vladivostok in 2012. So I think that Anastasia tries to portray that this actual period from 2012 is the Russia's tactical and strategic movements towards the east, right? And since 2014 is actually the brand new strategy of Russia. Maybe it's not the new strategy, of course, but still it's maybe another impetus towards the launch, towards the promotion of Russia's orientation on the in the East.
Good. No, thanks. Glenn, just briefly, thanks so much for your geoeconomics. You stressed that, that the EU's to enhance leverage and, in negotiating externally. And I just wanted to, there's lots we're concerned. I don't want to bring other people in, but I just want to talk about this hegemonic or hegemon issue, which you touched on. That, in other words, for the European Union, we have an external hegemon, if you like, as part of this Atlantic community. The United States is external. Whereas what's interesting, of course, is that within the EEU, you have an internal hegemon, whether you like it or not, just by the sheer size. You touched on that. Obviously, in the EU, you have Germany potentially, but just think, for 30 years, everybody's been obsessed on how to constrain and stop Germany becoming this hegemonic force within the EU. And so I just wondered whether, you had a comment on this internal coherence of it. And, I'm using hegemon as in a neutral way, but nevertheless, dominance is dominance.
Well, it would assume that states are seeking sovereignty maximization. So, for example, well, if you look in the EU, in any of the countries, for example, Italy, if it wants to have certain greater influence in the world, it really can't do it on its own. It's recognizing that in this bigger world, it needs to, it needs to, even pan-European hegemony, it needs the European Union, membership there. However, at the same time, it's seeing within the EU that you're having this internal hegemonization that power is concentrating in Germany, and to the point now where even the Italians are questioning whether or not they're able to revive their economy and reverse this economic decline within EU institutions. So you have this again, you have this dynamic where you have to balance the internal distribution of power with the external one, and again, that I see that as a challenge for the Eurasian Economic Union. Again, it can also make it more able to act if you have one central power, much like in the EU. The Germans can get the ball rolling, and the same within the Eurasian Economic Union. I'm just pointing out that the ability to enjoy this internal cohesion, it does. Yes, this internal hegemonization, it can become a problem. Again, like you used the example of Belarus and Kazakhstan, because they're usually the ones who will not necessarily align themselves completely. For example, with not sanctions, for example, if they say it is beneficial in terms of improving the symmetry of power within the Eurasian Economic Union. So it's I see that as being one of the major challenges. This
But on the other hand, the institutions are established precisely to as on equal basis to even it out a little bit. So
but that's why I think the European Union will have similar challenges as the Eurasian Economic Union, because the EU had a nice distribution of power. You had the Germans, the French, the British, the Italians, but now obviously the British left. The Italian economy is downward spiral. The French future is also not clear. Meanwhile, power is concentrating in Germany. What I mean is, when there's not an internal balance of power within an institution, the weaker members might seek external support. So, for example, Poland has attempted to diversify its trade a little bit away from Germany and reaching out, for example, to the United States. And so it can impact the internal cohesion of an institution. And again, you can see similar tendencies within the Eurasian Economic Union. However, I guess one benefit of the Eurasian Economic Union is you have these very powerful states on each side. Again, I guess countries like Russia benefiting a little bit that they're not the leading economy in this greater Eurasian space. As for example, when the Kazakhs feel the intruding influence of China, they have greater incentives to align themselves within the Eurasian Economic Union, even though it doesn't have that internal balance of power.
Thank you. As for Yekaterina's paper, I just no particular comment, just to simply I found it interesting to see how the rules of competition with direct effect and the way that so much of this legislation is based on Russian legislation itself drawn from the EU's, and the way, in other words, it works as a conveyor belt into it. So that was just a comment, no question there. So that takes us to the, I mean, Kirill, I think, Kirill is back. But I haven't, I mean, I'll leave that. Maybe just to save time. Right, so just some overall.
So you have like 3 questions in the chat, I think, about
yes.
the law of the Eurasian Economic Court. If he wants to answer, just in case.
Yes. Oh, yes. There you are. Yes. Good. Great. So maybe do that.
I mean, I can, Richard, I can answer your question now, and Kirill can like take his time and read the questions in case.
I'm fine.
No, so Kirill, okay, Kirill, if you could answer the questions now in the chat, please. There's one.
Absolutely. Well, there is a question from Alina Arnautova, which is quite fascinating, taking into account that we don't have a preliminary ruling procedure in the Eurasian Economic Union, and the question is about whether, basically from the perspective of national court, there is a possibility to provide a basis for further regional integration. And indeed, basically, the preliminary ruling procedure, as the historical example of the Court of Justice of the European Union shows us, is perhaps the most important instrument to ensure a uniform interpretation of the law. And without this, for now, we do rely on a sort of implicit dialogue between the Court of the Eurasian Economic Union and Supreme National Courts. Particularly, we have a successful dialogue with the Supreme Court of the Russian Federation, who regularly cites the advisory opinion of the court, and previously it used only to cite the cases, the judgments in disputes relating to customs, to the classification of goods, but we see that more and more now it cites legal positions, even the legal position that we discussed relating to the level of human rights. And for instance, the Russian Supreme Court used this as a basis for reaching the conclusion that the decisions of the Eurasian Economic Commission could not have a retroactive effect. So we do have this possibility, and we do for now rely on the role of national Supreme Courts. However, without a uniform this legal mechanism, I believe that in the end we will have huge problems of ensuring uniform applications of the Eurasian Economic Union law across all the 5 member states.
Thank you.
Thank you.
There's some more questions about Iran. Anna, who do you think should handle that, or would you like to comment on those?
Do you mean the Iran-related questions?
Yes, there's a whole stack of them. Yes.
I thought that either Anastasia or Alexander would, because I think it's more like geopolitical IR questions. But I can take the question that I thought maybe Kirill would take, but I'm fine with that. With another legal question regarding the Eurasian Economic Union law. There is a question, well, it's a law or like requirements. What are the requirements in the law to join the Eurasian Economic Union? As far as I know, and obviously our experts working in the Court of Eurasian Economic Union can always complement. As far as I know, the main conditions are to fill certain political and economic conditions, as well as accept all the law of Eurasian Economic Union, meaning the primary, secondary law as law of that state, as well as decisions of Eurasian Economic Commission, also as law, as domestic law of the state. That's what I know. So it's quite similar to the process of the membership of EU law, except that, as far as I know, again, maybe it's not the case, there is now this part of more human rights and the rule of law that is more complicated and much more sort of not burdensome, but much more complex in the EU accession, that the rule of law and this side is more complex in the EU accession than in Eurasian Economic Union. I think in Eurasian Economic Union, it's rather economic and general political conditions, something like that. I don't know if Kirill wants to complement.
No, I think you got it all.
But I just, before moving away from those questions, maybe just briefly, and then I'll open it out to other questions, is on a political issue. And Glenn, maybe then move to Alexander, but Glenn, maybe you would like to comment, on the geopolitics of Iran. You can see the chat, can you?
Oh, yes.
And the top one, I'm thinking in particular of the top one and one bit further down, but basically Iran and it's in your larger model. So if you could be kind enough to comment on that.
Well, I guess, yeah, in the larger model, because, well, the process of integration is obviously difficult with Iran, and complex. However, there's a reference to Iran's pivot to the east, and obviously this is, for many reasons, including sanctions, strategic interest of Iran to become less reliant on Western technologies, its transportation corridors, as well as the different financial instruments, which are all impacted by sanctions. So I think it would be quite well challenging, but also there's obviously benefits for countries like China and Russia to accommodate it, and you already have seen this being brought up by Tehran, where they argue the future effectively belongs to and needs a cooperative relationship with countries like Russia and China. Now, I think because China is already entering Iran economically in a big way, I guess there would be greater incentives or push for the Eurasian Economic Union to also accommodate Iran to a greater extent. So again, you don't have this excessive concentration of influence only in China within this Eurasian space. I guess what would work maybe against it would be some of the difficult positions that Iran finds itself in. I guess, especially for countries like Russia, are quite cautious not to be locked into any kind of alliance or exclusive bloc system. So again, the whole idea of trying to get along with everyone and have this interregionalism, I guess the concern is being too close with Iran. It could alienate countries like Israel or Saudi Arabia, but I don't be beyond that. Sorry?
You don't want it to become a union of outcasts, as it were.
No, yeah, exactly. And it's the same logic often why Russia might be a bit cautious about entering, for example, an official military alliance with China. They would then begin to alienate, the Japanese, the Indians. So there is, there is some caution in there. However, like I said, I think it has many strategic interests for the Eurasian Economic Union to accommodate Iran to greatest extent as possible, both for industrial cooperation, but also, at least from the Russians, you have this north-south corridor from Russia, Iran, and India, which would make sense to bring the Iranian closer. Also, when it comes to development of financial instruments, the Iranians, not a guinea pig, but they have a lot of experience getting around sanctions. But I guess I see a lot of the incentives in place to accommodate Iran to a greater extent. I think the sanctions will further complicate the integration process by, as you framed it, not make it a club of outcasts.
In inverted commas, yeah. Yeah, lovely. Thank you. Maybe before we go on to maybe the summing up, please, is there anyone who would like any questions? Does anybody? We've got quite a few participants who, would prefer not to do it through the chat, but simply viva voce. Is there anybody who would like to put a question to anyone or a comment, please?
And if you let me, I can comment on also the Iran question.
Yes. Okay.
Yeah. So so I will combine both Mariam and Saif questions because they complement each other. So yes, definitely Iran is wanted to shift its foreign policy towards the east because of the sanctions, right? Because of the fear of isolation from the West, right? And the no guarantee that Joseph Biden will lift the sanctions, the anti-Iran sanctions, and India as well is one of the major importers of Iran mineral resources. So of course, for Iran is the question not only about the diversification, but also about the economic survival, right? So that's why, of course, Iran wants to put itself into the let's say economic shield, which Eurasian Economic Union is supposed to be for Iran's perspective. But as for the Eurasian Economic Union and the problems, so of course, one of the major problems is sanctions, right? Because Russia is under sanctions, and Iran is under sanctions. So especially the U.S. sanctions have the extraterritorial nature, right? The extraterritorial character. So that's why it will be very hard for the Eurasian Economic Union to let Iran join the Eurasian Economic Union. The other problem was, of course, the Eurasian Economic Union is mostly the landlocked union, right? So the only border with Iran has Armenia, which also has a lot of problems in terms of the geography, right? So that's why not only the geopolitics or geoeconomy, but also the geographical factor even matters in terms of the development of relationship with Iran. So that's why I will be very surprised if Iran will become a member state of Eurasian Economic Union, especially the Eurasian Economic Union currently doesn't want to expand its membership, right? Because Uzbekistan is now an observer state in the Eurasian Economic Union, and of course there are many talks about will Uzbekistan finally join the Eurasian Economic Union, which is still there's no clear answer. But as for Iran, I don't see Iran in the Eurasian Economic Union in foreseeable future.
Can you comment also on Tajikistan's possible membership, because those are the two, as it were, in the waiting room?
Yeah, thank you. The same way I don't see Tajikistan a member state of Eurasian Economic Union in foreseeable future, and the clear explanation is that any new member state of Eurasian Economic Union will actually hit the Eurasian Economic Union in terms of the institutions, in terms of the agreements, because Eurasian Economic Union is once again it's a very young organization, it's just 6 years. So and the legal base, the supranational base of supranational nature of Eurasian Economic Union is still in the development, still in the making. So any member state that will join Eurasian Economic Union, no matter Uzbekistan or Tajikistan or maybe Turkmenistan, so it actually will hit the Eurasian Economic Union not in terms of the economy, but in terms of the normative power, let's say. And of course, countries like Armenia and Kyrgyzstan, which are very dependent on the transfers from Russia, first of all, right? So for their perspective, they will be very sensitive if Tajikistan, which is very dependent on the labor force, first of all, from Russia, right? They will, of course, they will be the spoilers in terms of not letting countries like Tajikistan during the Eurasian Economic Union, because they are actually they are once again very dependent on labor force in terms of their GDP.
Anna.
Richard, yes, that's really, Alexander, that's so timely that you brought about the question about the labor force from these countries, especially in Russia, right? In Moscow, it's like so obvious, because we just received a question from Andrei Leonov regarding the migration within the Union on the one hand, and the very recent pension agreement, which has been adopted by the countries. So it's like you can read the whole questions, a longish question in the chat. So, I mean, the agreement is one thing. Another thing, is, from my perspective, I'm a lawyer, is as how it will be interpreted by the Court of Eurasian Economic Union, because, for example, in the European Union, the Court issued a series of different decisions, which also showed the stance of the Court and the political economy within the European Union in different times. So the sort of the line went from let's give the pension and other social benefits to any member of the European Union coming from one country to another, for example, from Romania to Germany, so anyone can have any benefit. So the position shifted from one extreme to another one, like really, let's not give anything, let's leave all that to the appreciation of the states. So the agreement is important, is one thing. The interpretation of any agreement by the Court in the regional formation, like the EU or the EA-EU, is another thing. So exactly with this agreement, for example, we will see what is the role of the agreements and what is the role of the Court in the Eurasian Economic Union. Hopefully we'll see it soon. Agreement in itself is not a Bible. It also has its implementation, its interpretation, its enforcement in practice. So we will see how it works. But the migration issue, especially from these countries like Armenia, like Tajikistan, like Uzbekistan, actually all countries, maybe except Kazakhstan and Belarus, to Russia, like the migration of labor force is huge. It's both a good thing and an issue. So that will be my question. Maybe somebody wants to add. Also, Richard, I gathered that you had like a question to me, like from
Yes.
to my presentation regarding global value chains or something, or like no?
No, that was something else. But
Okay,
yeah, I mean, I just had some sort of overall comments, which in particular to you, but you know, in general, one of them, which is exactly what you've just talked about, and that is, you know, the equivalent. There's, you know, one. I mean, some of the overall themes, if you like, and one of the themes is the way that the development of the EU is complementary to that of the European Union. That in some ways, you know, as Alexander says, the EU is a very young body, but the European Union is already middle-aged, if not getting, some people would say, senile. But it's the fact that, you know, there's big debate lately about the role, amongst many things, European Court of Justice, ECJ, was the driver in many ways of integration. You've just alluded to. Yes, but and then, you know, I wanted to make it more explicit, your evaluation of the EU court, and it's you know, it's would you say, you know, Luc van Middelaar talks about the European Union and he calls it almost a coup d'etat, the way that the judiciary made politics in the EU, and of course this has prompted a huge debate. And so maybe, you know, you to comment on, you know, clearly it's a weaker, and it doesn't have quite that the judicialization of policymaking in the EU. And just a thought, can you comment, please?
oh, sure, I can. I mean, my
Or
comment
somebody,
will be
Kirill
really
as
an
well.
external one, and maybe Kirill can complement it right after or like later in another article, or by like maybe the decision of the court will complement later. So starting from the ECJ, for example, for those who are not lawyers, for those who are not Europeans, for both non-lawyers and non-Europeans, the role of the ECJ was so crucial that really everyone needs to read one article written by Antoine Vaucher, who is not a lawyer, who is a political scientist and a sociologist, who did like a sort of investigation journalism of just one decision, Van Genten loss. And so this decision was like so crucial, and the role of the ECJ in the harmonization of different legislations, which were really different back in the days of the member states. So the aim was the harmonization of legislations and really this market integration, the creation of the common market by the creation of the principle of the direct effect, meaning that the law of the European Union, back in the days, the law of the European Economic Community, applies directly in every member state. And that, for example, you can go to the national court and you can ask a preliminary ruling, which is, as Kirill mentioned, the preliminary reference or preliminary ruling procedure. So you can refer your question to the national court, and the national court can refer it to the ECJ. And the second principle, created the next year, 1964, by the way, the principle of primacy or supremacy of European law, meaning that if there is a conflict between a provision in national law of a member state of the European Union and between a provision of EU law, of European law, the provision of European law prevails. That's basically, and that the legal order of the European Union is autonomous order, which is different and distinct order from both domestic legal orders of member states and international law. That's so huge. So the court, for different reasons, for the market integration, but I think also for power reasons, right? From institutional theory perspective, it's to how to say, to become a powerful institution. The Court of Justice of the European Union, back in the days of European communities, really became this powerful creature. But I think that Eurasian Economic Union, to some extent, or to sort of great extent, is learning from the EU. And they're learning on the successes and on the failures of the EU. And I think the whole organization is learning from the EU, and they know what happened because at some point they gave too much of power or too much of freedom of creation, of creativity to the ECJ, for better or for worse. I think that the decisions like Van Genten laws and the direct effect and Costa against NL and the primacy of EU law accelerated the market integration, the creation of the single market of the EU, which is great. Now, again, all the institutions and all the people working in the institutions of Eurasian Economic Union know what it means. So I don't know to what extent this institutional gambit will allow the Court of Eurasian Economic Union to be as activist as the ECJ, to what extent they will allow this judicial activism, or at least the judicial assertiveness, right? There is another question, which is the institutions of the Eurasian Economic Union. In the EU, we have the parliament. We don't have the parliament in Eurasian Economic Union. In the EU, we don't have the Supreme Council, consisting of the presidents of the countries, and we have the Supreme Council in the Eurasian Economic Union. So this is also the power play, the larger power play. So it remains to be seen how creative the Court of Eurasian Economic Union can be, and also how the other institutions will allow this court to be creative, to be active, the judicial activism, or at least the judicial assertiveness of that court. So that's, you asked me a very difficult question.
Yeah, and you gave a very complex and great answer, because what you've done is highlighted the, one of the larger, deeper processes going on is that so much going on in EU and other regionalism is looking to the EU. So the EU acts as both a model, but as you suggested, it's also in some ways a warning, not a warning in a bad sense, but a warning so they can learn from, if they don't want to go that path, how to avoid going that way, like, as you say, judicial activism, like in the US as well, big debates about the Supreme Court making law. So these are, interesting. So it's both a model to follow and something to, and some pitfalls to avoid, and to stir that path. Yeah, we're coming to the end, and so I'm not going to completely end, but what in that context, it's fascinating how so many of the debates, I think, which we've heard this morning, do touch on those larger questions, which are eternal ones, if you like, about functional versus deep, spatial integration, political integration, and so on, and the tensions, as Anna just highlighted in the case of the ECJ and the EU Court, that there's all sorts of elements going on. And, you know, one of the debates which, you know, a lot of this can be fitted in, some of you will have seen, you know, Christopher Bickerton and the idea of a member state. And in other words, it's the actual member states which make part of this Eurasian Union, that the very concept of statehood begins to change, because we've been focusing this morning on the institutions, and that's why I thank the editors of this volume for having brought together, because what has come out for me certainly this morning is that these institutions matter, that they also have their own genealogy, their own difficulties and concepts, and they're embedded in larger issues like you know, geoeconomics and so on. I was going to say something about globalization, but you know, just maybe just a quick comment on that, because you know, globalization was always an ideology. We're talking about globalization, two levels, obviously on the technical level, communications, transport links, financialization, these things were going on. So there's some things clearly going on, and these debates which our speakers and your book addresses, you know, are important. But at the same time, it's all embedded in a larger political framework. And globalization was on the other side an ideology of state disempowerment, you know, neoliberalism and so on, a state formation. And it's interesting that our debate takes place at the moment when it's not just superficial deglobalization, but it's that deglobalization of the globalization ideology, if you like. And it's an interesting intersections of the debates you've had, because I've really found it important, because, you know, we're talking about Eurasian Economic Union, which to many Western observers lacks a certain legitimacy. For good or ill, that's why European Union doesn't fully engage and such like. And what I think we've seen today is that, you know, this is a serious engagement, you know, with the normal difficulties. Globalization is, you know, I'm not sure that it's a very good framing. You know, you said the three big processes at the beginning, globalization is one of them. Yes, in purely technical terms of communications, trade flows and so on. But as I said, deglobalization in ideological terms is going to be a challenge to a regional integration. It won't stop it, but it's going to raise a different set of questions, dealing with complex interdependence, as the sort of thing that Glenn and some of the other speakers talked about. And therefore, my bottom line in all of this, maybe drawing, you know, itogi, the results of the discussion is, you know, maybe we're moving towards a more sophisticated vision, not globalization as the overarching concept, but creative forms of internationalism, that sovereign internationalism, and that what this is, sovereign internationalism, then no longer takes away the automaticity of globalization. You know, it's automatic. You have to do this. New Labour in the UK said the government can't do this, that, and the other because globalization forces us. But we're talking about empowered governments, and a number of speakers have addressed this, who want to engage because it suits their interests. Iran, Vietnam, and why they sign these agreements, and therefore, you know, we're talking about a rational self-interest, and therefore sovereign internationalism, sovereign states, but levels of internationalization. And internationalization is what I think our discussion was today: is legal, institutional, political, geoeconomic facets. So, so I mean, that's what I take away from it. I think it's been a great discussion, and I thank all the speakers. I thank the editors in particular, Anna, who's been with us. Alexander, thank you very much for organizing this event. I think it's been you know, really useful. And thanks everybody for participating, and for those who've put comments in the chat, but for everybody who've given up the time this, well, it's morning in England, it's afternoon, I think, in Moscow. So, so thank you very much, and wish you all the best. Goodbye.
Thank you, Richard. Thank you so much. Thanks everyone for joining us and for all the questions. And please buy the book and read the book.
Good.
Okay, so we were all on time.
Yes. No, everybody showed a lot of discipline, academic discipline, and very good. Yeah.
Yeah, academic discipline on Zoom. Thank you so much, Richard. That was great, like for moderating and commenting. That was
My
really
pleasure.
good.
No, I enjoyed it.
Yeah.
Thank
And
Thank
thank
you
you,
very much,
Alexander,
Alex.
for
Yeah.
organizing. That was
Thanks
very
for
good.
the invitation, and thank you very much for moderating and taking part of this seminar. Thank you.
Okay. So
Goodbye.
that's
Bye-bye.
it.
Yeah, bye bye. Thank